She set the briefcase on the table without a word. Worn black leather. Brass clasps. The kind of case that had seen the inside of 100 courtrooms and earned every scratch. Every eye in that wood-paneled chamber found her. The defense attorneys in their tailored suits. The bailiff by the door. The 12 jurors who had been watching this trial stretch across 11 grueling days. Judge Harold Prentice looked down from the bench with the particular expression of a man who had already decided what he was looking at. What none of them knew, not the judge, not the lead prosecutor across the aisle, not the senior partner who had tried for 3 years to keep her out of this firm, out of this case, out of this building, was what was inside that briefcase. And what was inside that briefcase was about to end 4 careers before lunch. 3 years earlier, Diana Okafor had walked into the marble lobby of Hargrove & Crane carrying everything she'd earned in a leather portfolio that weighed less than the work it represented. She was 31 years old. Howard University School of Law ranked 4th in her graduating class. 2 years clerking for a federal district judge. The kind of clerkship that signals, before an interview even begins, that someone with real authority trusted your analytical mind. 3 years of litigation experience at a well-regarded Atlanta firm where she had tried 6 jury trials and won all 6. Not most. All of them. Her record was the kind that, attached to a different face, would have gotten her a corner office conversation on the first call. Hargrove & Crane was a 90-year-old white shoe firm occupying 6 floors of mahogany, brass, and institutional confidence in downtown Calverton. 47 attorneys. A client list that read like the county's economic history, generational wealth, commercial real estate, corporate defense. They had never made partner a black woman. In 90 years, not once. Diana knew this when she accepted the interview. She took it anyway, because Hargrove & Crane handled the largest corporate defense cases in the state, and if she intended to do the work she had decided to do, she needed access to the rooms where those decisions were made. The partner who interviewed her was Gerald Whitmore, senior litigation partner, 26 years at the firm. The kind of man who wore his authority the way other people wore cologne, constantly and without awareness of how strong it had gotten. He reviewed her credentials with the unhurried pace of someone completing a formality rather than making a discovery. He asked her twice about her undergraduate institution. Both times she answered without blinking. He mentioned twice that the firm had a particular culture, and that fit mattered as much as credentials. She told him she understood precisely what fit meant. He offered her an associate position. Lateral entry, mid-level. Below what her experience warranted, below what he would have offered a white male candidate carrying the same record and fewer wins. She accepted, because the room mattered more than the title. She could work with the title later. She joined Hargrove & Crane in September. The first 6 months, Diana worked without drawing attention to herself as anything other than someone who delivered. She billed the most hours on her floor 3 months running. She won a summary judgment motion that 3 senior associates had privately told the assigning partner was unwinnable, and she did it in a brief that one of the named partners passed around the litigation group as a model of how argument construction should work. She wrote nothing on firm social channels. She attended the cocktail hours she was expected to attend and said nothing remarkable at any of them. She was mapping the place, learning the architecture of how cases moved, who had real influence versus the influence of title, which partners paid attention to associate work and which ones rebranded it as their own. She filed every observation and said nothing, but the firm noticed her the wrong way first. Gerald Whitmore began assigning her the tasks that senior associates avoided: document production oversight, due diligence reviews on matters that would never go to trial, research memos that a junior partner would rewrite before any named partner saw them. She completed each one with the same care she brought to the work she actually wanted. She was learning the files from the inside. Every matter she touched gave her another piece of the firm's client history, and she was patient in the way that people are patient when they understand that the goal is long and the steps are real. 14 months into her time at Hargrove and Crane, Gerald assigned Diana to the Meridian Holdings defense team. Third chair. Document review and research support. She did not show, at any point, how important this assignment was to her. Meridian was a real estate development company facing a class action lawsuit from 47 former employees who alleged the firm had systematically defrauded them out of retirement contributions over a 6-year period. The case was large and complex. 47 plaintiffs, 6 years of payroll and benefits data, hundreds of thousands of pages in discovery. Gerald was lead counsel. Second chair was a senior associate named Carter Webb, polished, well-networked, the kind of lawyer who worked hard enough to stay useful without ever threatening the people above him. Diana was assigned the full document review. All of it. Gerald Whitmore assumed she would find nothing interesting. He had made a career of assumptions like that. 2 weeks into the review, Diana noticed something. It was subtle enough that a normal reviewer would have skimmed past it. 3 times across the 6-year discovery window, internal emails between Meridian's CFO and its payroll vendor referenced a reconciliation process using terminology that didn't correspond to anything in the company's official records. Contributions were logged as received on the plan administrator's end, but the reconciliation emails described a secondary movement, a downstream routing that had no matching account in the discovery production. She flagged it in her review log. She walked it to Carter Webb's office and explained what she'd found. She used specific document numbers. She laid out the pattern clearly, the way a former federal clerk lays out anything, precisely, without editorializing, with the evidence arranged so the conclusion was unavoidable. Carter Webb thanked her and told her she was misreading the accounting terminology. Standard payroll processing language, he said, twice, in 2 sentences, with the particular confidence of someone who hasn't actually checked. Diana said she understood his read but wanted to escalate the flag to partner level anyway, given the exposure for the client and the firm. Carter said he'd handle it. 3 days later, Diana returned to the shared document review system and looked at her flag. It was gone. Not edited, not reclassified. Gone, the review log showed clean notes in her name. No flag, as though she had reviewed those documents and found nothing worth noting. She checked the version history. The notation had been removed 14 hours after she'd brought it to Carter Webb. She had kept a personal copy. Time-stamped, she always kept copies. Diana sat with what she knew for a full week. She did not act quickly. She thought carefully about every possible reading of what she'd found. The most charitable interpretation, the most alarming interpretation, and every version between them. She was an attorney. She understood discovery obligations. She understood what the rules of professional conduct required when counsel discovers evidence of client fraud. She also understood that she was a third-year associate at a firm that had never made a black woman partner, and that what she was looking at could be explained as nothing, or it could be what it looked like. She needed to know which before she moved. She went back into the documents. All of them. She stopped billing the hours she spent because she didn't want anyone mapping her time to specific files. She ate at her desk. She worked evenings and weekends and said nothing about it to the colleagues she passed in the hallway each morning. From the outside, Diana looked like a third-year associate grinding through a production assignment. Inside, She was building the most important case she had ever touched. Except this one was against the firm she worked for. She started with what she knew: the 3 reconciliation emails. The routing terminology that didn't match the plan administrator on record. She pulled the deposition transcripts for the Meridian CFO and read every page with the original emails open beside them, looking for moments where the deposition language swerved away from precision. She found 2. Small pivots in wording, the kind a careful lawyer coaches a witness through, where the witness doesn't technically lie, but the question doesn't get an honest answer either. Someone had prepared the Meridian CFO to avoid this subject. Someone had seen the reconciliation emails and known they were a problem, and decided to paper around them rather than address them. Diana noted every instance. She built a timeline that now stretched across 43 pages of her own handwritten notes, a habit from her clerkship days, because a judge had told her once that handwritten notes were harder to subpoena and easier to trust in your own memory. The secondary account materialized like a photograph developing in slow motion. 3 separate deposit records, requested individually over a 2-week period so as not to trigger a single alert on any one request, showed contributions from 12 of the 47 plaintiffs being routed through a clearinghouse that did not match the plan administrator listed on record. The clearinghouse was registered to a shell entity in Delaware. The shell entity's corporate filing pointed to a second entity registered in Nevada. The second entity, when Diana pulled its ownership documentation through public records, carried the name of a Meridian board member, Thomas Ashford. The same Thomas Ashford who had personally authorized the retention of Hargrove and Crane as defense counsel 3 years prior. The same Thomas Ashford whose office, on the executive floor of Meridian's headquarters, had a framed photograph of himself and Gerald Whitmore at a charity golf tournament, smiling, arms around each other's shoulders, sometime around when the contributions first went missing. Diana set down the last document at 11:40 on a Friday night in her apartment, and she sat completely still for a long time. She did not move for perhaps 15 minutes. The number she had traced, not estimated, not approximated, but traced, dollar by dollar, account by account, was $2.3 million. Retirement contributions belonging to 12 working people. People who had earned those contributions over years routed into an account tied to the man who had hired the law firm that was supposed to be defending against them. This was not a document production gap. This was not accounting ambiguity. This was fraud. Deliberate, sustained, and covered up. And someone at Hargrove and Crane, at minimum Carter Webb, and quite possibly had seen the flag she raised and removed it from the record, rather than address it. Diana thought about the 47 plaintiffs. She had read their names hundreds of times in the course of the review. She knew which ones were retired and living on fixed income. She knew which ones had families. She knew from the complaint filings what they had trusted those contributions to become, and what it had meant when the statements stopped adding up and no one at Meridian gave them a straight answer. She thought about her father, who had spent 30 years as a school administrator and retired with a pension he'd counted on and deserved. She set the documents in a careful stack. She labeled the stack. She placed it in the worn black briefcase she'd carried since law school, the one her mother had given her the morning of the bar exam, and she zipped it closed. She spent Saturday thinking and Sunday deciding. She called no one at the firm. She called the federal judge she had clerked for and asked him a question framed carefully in hypothetical terms. He told her what she already knew. The rules of professional conduct were not ambiguous. The obligation ran to the court and to justice before it ran to the client or the billing relationship. And the path forward, while professionally costly, was clear. She did not waver after that call. The decision had already been made. The call was just the last confirmation she allowed herself to seek. Sunday evening, she called Sylvia Park, plaintiff's lead counsel, and asked for a meeting the following morning. She disclosed the nature of what she had and the basis for the contact. Monday morning, she sat across from Sylvia Park in a conference room 2 blocks from the Hargrove and Crane building and laid out every document, every date, every chain of custody notation she had assembled. Then she drove directly to a copy shop, made 3 sets of everything, and called the State Bar's ethics hotline to document the disclosure on the record. She did not tell anyone at Hargrove and Crane. By Thursday, Sylvia Park had filed an emergency motion to compel supplemental discovery. By Friday afternoon, the State Bar's Ethics Division had opened an inquiry into the handling of document production in the Meridian Holdings defense. Gerald Whitmore signed Diana's reassignment memo late Friday after case staffing realignment, it said. He was confident she would understand. She was smart, he had always thought that, smart enough to know when to be quiet. He walked into Courtroom 7 on Monday morning with 26 years of practice behind him, a co-counsel who had never questioned him, and a client whose exposure he believed he still. Diana was already seated in the gallery when he entered. Second row. Worn black briefcase on her lap. She did not look at Gerald Whitmore when he came through the door. She watched the jury file in, one by one, and she counted the faces, and she waited. Gerald saw her. His jaw tightened by a fraction that only someone watching carefully would. He said something low to Carter Webb, leaning sideways without breaking his forward-facing composure. Carter looked at Diana. Just a glance, the involuntary kind. The kind you make when you're checking where something dangerous is, and then he looked forward again. Too quickly, and with the particular stillness of a man working hard to look. Diana watched all of it without expression. Judge Prentice brought the session to order and directed the parties to be seated. The courtroom settled into the formal quiet of 11 days of accumulated procedure. The jurors arranged themselves in the box with the slightly glazed efficiency of people who had been doing this long enough that the rituals had become automatic. The gallery sat. The stenographer positioned her fingers. Sylvia Park rose before the first argument was called and said she had a preliminary matter. Supplemental evidence, she said. Responsive to a deficiency in the defendant's original discovery production, filed pursuant to the emergency motion of the previous Thursday. She spoke without drama, in the measured tone of someone who had prepared this moment across many late nights and needed no additional ornamentation. Gerald Whitmore rose with the full authority of 26 years behind him. Procedurally improper, he said. An ambush tactic, a last-minute disruption designed to prejudice the jury and circumvent the orderly management of discovery. His language was precise, and his voice was controlled, and every word was chosen to make the motion seem unreasonable, which was how Gerald Whitmore had won arguments for most of his career. By making the opposing position seem like the problem. Sylvia Park did not argue back. She simply said the evidence had been in the defendant's own document production the entire time. It had been produced by Meridian Holdings. It had been reviewed by Hargrove and Crane's own designated document review lead. She paused. She looked at Diana. The courtroom looked at Diana. Diana unsnapped the brass clasps of the briefcase and opened it. She removed a single bound document. Color-coded tabs, 12 of them, each a different color corresponding to a category of evidence. Numbered exhibits running to 263 pages. The kind of organization that comes from weeks of preparation by someone who has done this work before and intends never to have the document questioned on procedural grounds. She handed it to the bailiff without looking at Gerald Whitmore. The bailiff carried it to the bench. Sylvia Park's co-counsel simultaneously placed a copy on the defense table, in front of Carter Webb, who did not immediately pick it up. Gerald Whitmore reached across Carter and took it himself. He opened to the first page. Read. He turned to page 2. Page 3. His right hand, resting flat on the mahogany counsel table, tightened, slowly, almost imperceptibly, until the knuckles went white against the dark wood. Something shifted in his face. Not a movement, but the absence of one. The precise moment when a professional mask stops being the expression and becomes the only thing holding the expression together. He knew. Within the first 3 pages, he knew exactly what 260 more contained. He had spent 26 years in courtrooms. He understood evidence the way musicians understand key signatures, not by thinking, but by feeling the shape of it immediately. He felt the shape of this immediately. 47 seconds passed. The courtroom did not make a sound. Judge Prentice read for 11 minutes. Every page. The jurors watched him and did not speak. The gallery watched the defense table. Thomas Ashford, seated in the front row of the gallery directly behind the defense, had stopped moving in the way people stop moving when fear has gotten ahead of their ability to process it. His personal attorney, a separate man from Gerald, not a Hargrove and Crane lawyer, leaned close and said something. Ashford did not. Carter Webb had pushed his chair back from the counsel table by perhaps 3 inches. That was all. 3 inches. But in a room that quiet, 3 inches was a statement. When Judge Prentice set the document down, he removed his glasses with both hands and folded them deliberately on the bench in front of him. He looked at Gerald Whitmore, not at the table. At Gerald. Mr. Whitmore. His voice was level, measured, almost gentle, in the way that very serious things sometimes come wrapped in very quiet tones. I am going to give you 60 seconds to tell me, on the record, whether you were aware of this secondary account prior to the submission of the original discovery. 60 seconds in a silent courtroom is not 60 seconds anywhere else. A silent courtroom at this particular moment is not any courtroom Diana had ever sat in. Gerald Whitmore was still. His hands were on the table. His face held its professional arrangement. He was a man who had spent 26 years building the ability to perform composure on, and he was performing it now with every resource he had left. At 47 seconds, he said, I would request a brief recess to consult with co-counsel. Judge Prentice said, denied. I'll note the time remaining. The room held. At 59 seconds, Gerald Whitmore said 3 words, quietly, in the measured delivery of a man who has calculated every option and found no version of this moment that allows him to leave with what he came in with. I was aware. The courtroom erupted. The bailiff called for order twice before it settled. 3 jurors in the front row had exchanged glances so unambiguous that both attorneys on the plaintiff's side would later describe them identically in their case notes. Thomas Ashford was on his feet, his personal attorney gripping his arm. Ashford's face had gone from chalk to something beyond it, the expression of a man whose entire architecture of arrangement has just collapsed in a wood-paneled room at 10:43 in the morning. Carter Webb looked at the table. Just the table. For a long time, Diana Okafor sat in the second row of the gallery with her empty briefcase on her lap and her hands folded on top of it, and she was very still. The trial was suspended pending investigation. By the end of the week, the state bar had escalated the inquiry to formal disciplinary proceedings. Gerald Whitmore's license was suspended within 60 days. Carter Webb resigned from the firm before the month was out, and received a formal censure that followed him into every subsequent job application for years. Thomas Ashford was indicted on 12 counts. He pled guilty to 4 and was sentenced to 38 months in federal custody. The 47 plaintiffs were made whole. Every dollar of the $3 million, plus compounding interest from the period of diversion, plus a settlement from Meridian Holdings' restructured board that took the total recovery into 7 figures. Diana Okafor found her badge deactivated at 7:15 the morning after the courtroom session. No letter, no call. A locked door where her access had been. She had expected it. She had planned for it. 6 months after her termination, Hargrove and Crane settled her wrongful retaliation claim. The terms were confidential, but the filing described the resolution as substantial. The firm's managing partner issued a statement referring to regrettable circumstances 4 times across 2 short paragraphs, which told anyone reading it exactly what had happened and how little they wanted to say about it. Diana used a portion of the settlement to lease an office above a coffee shop on Meridian Avenue. Single room. Her name on the door. She took plaintiff's side employment cases, wage theft, retaliation, discrimination, on contingency, because that was where the people who couldn't pay for justice went, and because she had decided a long time ago which side of those cases she was on. Within 18 months, she had 2 associates and a paralegal. Within 3 years, Okafor Law had outgrown the office above the coffee shop and moved into proper space. Nothing like the marble lobby at Hargrove and Crane, but clean and capable and entirely hers. The State Bar featured her in their ethics publication. A regional law school invited her to speak at their annual ethics symposium. She stood at the podium and looked out at 200 second and third-year students and told them the story exactly as it had happened. The document review. The removed flag. The Sunday evening she spent alone deciding what the rules required. The locked badge in the morning. She didn't frame it as a triumph. She framed it as a choice. The kind of choice you either make or you don't. And the profession either means something or it doesn't. And you find out which in moments exactly like that one. A student in the second row raised his hand and asked whether she ever regretted walking into that courtroom. Diana was quiet for a moment. She thought about 47 people who had spent years watching their retirement savings quietly disappear and being told the math just didn't add up. She thought about a Sunday evening and a federal judge's voice on the phone telling her the path was clear even when it was hard. She thought about a locked badge and a settlement check in a coffee shop office and everything that had grown from all 3. No, she said, not 1 page. The worn black briefcase sat on the table beside the podium. She had kept it, not for sentiment, because it still worked. Because it had done its job. Some things earn their place, and you keep them for that reason alone. The students had no more questions. The lecture hall was quiet in the particular way that rooms go quiet when a truth has just landed exactly where it belonged. She had gotten used to that silence. She had learned, over 3 years and 1 very long Monday morning, that the truth doesn't need volume. It just needs the right room, the right moment, and someone willing to open the briefcase.